I'd like to begin by thanking Examiner Marissa Thine and her team for this invitation. I'd like to thank all of the examiners in attendance all over the country. Thank you for asking to hear our stories and gain our insights into the applicant's and inventor's perspective. Today, I'll be sharing the perspectives I've gained through my close work with Board Active and many other patent applicants. But these perspectives may not necessarily be the same perspectives of those shared by Board Active. I understand that our invitation to speak with you today is based on the subject matter of the patent portfolio and the technology it covers. But what makes this opportunity to speak with you all especially exciting is to briefly share with you the back-end process that you may not see. What happens in the boardrooms, the development team huddles, the investor meetings, the sales team meetings? What happens before the patent filing, during patent examination, and after patent grant? In our story, all of these aspects are greatly intertwined with the patent process. I know most of you are quite familiar with the typical American entrepreneur. Clear vision, strong leadership, a well-funded and resourceful team, a developed product, a sales and marketing team, backed by a small and impactful patent portfolio. But our story is more than typical. The Board Active story is one that exemplifies the American entrepreneur's reliance upon the U.S. patent system. Board Active started with their patent process concurrently with their development process. CEO Doug Pittman wanted to ensure his investors and his company that the direction they were going would be defensible from an intellectual property rights perspective. He knew that he would be going up against big players with big resources. Doug chose to rely on the U.S. patent system. Our story begins with patent searches. Doug commissioned multiple patent searches, some even being performed by former USPTO examiners. And after the first search, the Board Active team decided that we need to go back to the drawing board. Even after the second search, still, Board Active decided that we need to go back to the drawing board. Doug respected the patent system from day one. But I think it was after our third search, Doug decided upon what he believed was not only a good solution for the market, which you'll learn more about from him, but a solution that could be backed by patent protection and allow him to stand his ground against more resourced and established players in the field. Board Active operated with IP near the center of their technical and business development process. So it's not much of a coincidence that Board Active is presenting before you today. I don't mean that Board Active was a company centered around a patent portfolio who sees a patent as a winning lottery ticket. So what does it mean to have an early stage marketing software technology company with IP near the center of its focus? It means their patent team was present at board meetings. They were constantly presented with company vision, long-term strategy to make sure the patents are not only covering what's today, but covering what's planned for tomorrow. And in turn, the patent team would present a play-by-play update of their examination process throughout its duration. The patent team was present at weekly tech demos to review and to ensure that the patent team was up to date with the tech team's progress. The CTO and his developers were constantly reviewing the claims to make sure the claims and the technology were in alignment. The Board Active sales and marketing teams were trained on what can and cannot be claimed as patented or patent pending. We held company-wide corporate education on interpreting claim coverage, which is, by the way, not an easy task, but one that Doug insisted upon. He believed that every Board Active employee should know exactly what the patents cover because the patents were designed to capture the Board Active vision. Keeping IP at the center of the company kept the IP at the top of everyone's mind. I recall Board Active's pre-pandemic holiday party. The investors, employees, and their families were all gathered in a ballroom when the Board Active patent team had the pleasure to announce the first issued patent number. The room lit up like you've never seen a patent issuance celebrated before. Of the tens of hundreds of clients I've had the pleasure to serve, no one appreciated their patent rights and employed them strategically throughout their early development lifecycle as Board Active did. So why was Board Active so IP-centric? Board Active is well-funded. They raised money from close friends and family, whose families worked hard in American agriculture and decided to diversify their investments into American software technology. With the granting of patents, other investors join on board to help fund the IP development and sales process. All of them were led in large part by the faith and reliance upon the U.S. patent system. And in light of the success they've had in obtaining U.S. patents, we were advised to pursue continuations, divisionals, CIPs, and international filings all over the world. They understood that while it was hard to compete against the big players in the marketing and ad technologies, the backing of U.S. patents would level the playing field, be respected, and provide an asset to fall back on or leverage for further opportunities. To properly value the assets of the company, Board Active consulted and retained the industry's most credible IP valuation specialists. Their reports were stunning and quite pleasing. But as the sales process progressed, the boots on the ground were reporting a different story. Larger companies, some of whom Board Active even demoed their solution, began to deploy their own version of the Board Active technology. Large multinational competitors were springing up and pushing Board Active out. Still, Doug Pittman and the Board Active team were undeterred. The American investors renewed their commitment to Doug and his team and retained a dozen of specialized and industry-leading licensing experts, along with the backing of a patent litigation team, to offer their API SDK that even their competitors could white label and integrate into their own solutions. Surely, with patents and white-labeled solutions, the market would adopt the Board Active technology. Board Active learned that their respect for the patent system was not equally shared in the industry. They heard everything from, "We don't care about your patents are abstract, you won't be able to afford patent litigation against us, we'll throw everything into re-exam." These remarks were coming from companies everyone in this meeting knows of. As more time progressed, so did the unlicensed adoption of Board Active IP across the industry. This validated the Board Active vision, but diluted their market opportunity. Multinational companies were investing greater resources, and all the while Board Active technology was being marginalized. Investors began to lose faith in the patent system, and employees began to lose their jobs. So, what happens to companies like Board Active? Forward-thinking technology, dozens of patents around the technology, providing a technical solution for sale. Do they turn to patent litigation? Well, with the resources expended and the results obtained through attempts to license their IP and API, the investors are spent. Do they liquidate and sell their technology? Well, this is how many non-practicing entities or patent trolls acquire patent rights, preying upon companies who couldn't compete but have good IP. You must be thinking, Doug didn't try hard enough, his patent claims are probably too narrow, he probably didn't have the right team, or worse yet, his patents are probably not enforceable. I encourage you to review the patents for yourselves. Over the course of patent prosecution, multiple examiners have, in writing, performed their own searches, conducted their own assessments, and declared that there are no 101 issues. Dozens of references have been submitted in IDS filings, upholding our duty to disclose. Yet, regrettably, our system today isn't bound by your trained and professional conclusions. And we punt it back to those American entrepreneurs and investors to expend more hard-earned resources to prosecute, litigate, and then relitigate their issued patent rights. This is the unfortunate fate of many of the smaller American companies who wish to confront large multinational corporations just to respect their U.S. patent rights. Today, Doug remains undeterred. As you'll hear, he and his team are still developing the next move to stay ahead of the game. But he's yet to see a return on his team's investment in the U.S. patent system. I'd like to conclude with the following message. You play a key role in the lives and outcomes of thousands of American innovators who invest in and believe in the U.S. patent system. Your work has real economic consequences downstream. Thank you for putting in your time into every case. Thank you for standing by your decisions. You serve not only the United States Patent and Trademark Office, but you serve the American businesses, investors, engineers, scientists, and their families. You serve the American people who rely on the U.S. patent system, not just to compete internationally, but to promote human progress. Our entrepreneurs and investors challenge conventions, explore new limits in their innovation, and take big risks. Today I would like to suggest that the investment into the patent system should not be one of those risks they take. Thank you for your time and attention, and thank you for all of your efforts in the hard and extremely difficult work you do.